This is a story of second chances tragically squandered. We're about to witness Brianna Renee Mitchell face justice not once, but twice before the same unforgiving judge. Initially, she stands accused in a case involving a death, but the state makes a surprising move, reducing the charge to manslaughter. She's offered a plea deal that could keep her out of prison entirely, 10 years of probation. The judge, sensing something more beneath the surface, probes for the truth, asking the one question that cuts through all the legal jargon: why? Mitchell's answer is chillingly simple: I was scared. She's given a lifeline and a stern warning about making better choices. But the real drama unfolds when she reappears in the same courtroom less than a year later, her freedom hanging by a thread. This time, there are no more chances.
Brianna Renee Mitchell. Can I have parties announce for the record for the state?
Tom Nisbet for the state.
For the defense?
Ellie Piddle for Brianna Mitchell.
And are you Miss Mitchell?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
None.
Any objection from the defense? Ms. Mitchell, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
I'm going to make sure that you speak up. Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, we did.
Court will find that the state is in compliance with discovery. Ms. Mitchell, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Judge, no, the lesser included of manslaughter.
Any objections?
No objection.
Did you understand the state is proceeding on the lesser included offense of manslaughter? The range of punishment for that offense is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
And Brenda, my real time is now back up. Counsel, has your client been able to provide you with any defenses to this offense?
Yes, yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. I'm showing you what's entitled plea bargain agreement page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the agreement, the state is proceeding on the lesser included offense of manslaughter. They're asking that your punishment be assessed at 10 years in the prison. There's a $1,500 fine, and the state recommends community supervision. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
Yes.
State is at the plea bargain agreement.
Yes.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 10 years. There'll be a TAP evaluation, parenting classes, and CPS compliance. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
State offers Exhibit 1.
Any objection?
No objection.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Are we proceeding with sentencing or no?
State waives PSI. Excuse me, state too. Defense waives PSI if that's okay for court.
All right, State.
That's fine.
This is a critical moment that separates a routine plea from a real judicial inquiry. Judge Boyd isn't just rubber stamping a deal. She's trying to understand the human element behind the crime. Her question, I always want to know what were people thinking, is aimed directly at the defendant's conscience. Notice the long, uncomfortable pause that follows. The defense attorney looks to his client, but there's no prepared answer for this. This is where the facade of the courtroom procedure cracks, and we get a glimpse into the defendant's actual state of mind. Her eventual response, "I don't know, I was scared," feels hollow and insufficient given the gravity of a manslaughter charge. The judge's demeanor tells us she's not satisfied, and she's now going to dig deeper to assess whether this defendant is truly ready for the grace of probation.
Judge.
All right. Defense, anything you want to say on behalf of your client?
Judge, we just ask that you follow the plea bargain, please.
All right. Someone want to tell me why did this happen? Counsel, Ms. Mitchell? I'm trying to figure out what is her mental state. Why is she doing this? Why was she a part of this? I've read the.
Here, the case takes a deeply personal and tragic turn. In the middle of being questioned about her drug history and ability to support herself, Brianna Mitchell reveals that one of her twin children has passed away. This isn't just a defendant anymore, she's a grieving mother. You can feel the energy in the room shift. This single statement provides a powerful piece of context for her current situation and potential instability. It's a moment that could elicit significant sympathy from the judge, and it explains the request for CPS compliance and parenting classes. However, the court must balance this personal tragedy against the crime committed. While her grief is undoubtedly real, the judge still has to ensure the sentence is just and that the community is safe. It's a heartbreaking detail that complicates the entire proceeding.
Police reports.
Your Honor, I think, are you asking why she was a part of the offense?
The
Or
offense, yes. I mean, I read the police report. I always want to know, what were people thinking?
Her. Tell
I don't know. I was scared.
All right, if you drug tested today, what are the results going to be?
Maybe clean.
All right, have you ever used drugs in the past?
In the past, yes.
What have you used?
Marijuana, meth, and shrooms.
All right, and this CPS compliance, is there an open CPS case?
Yes, Your Honor. She is in compliance as we speak.
How old are your children?
Oh, she-
Kaylin, she's 11 months.
You only have one child?
Yes, Your Honor.
One of my twins passed.
Okay. All right, the court will sentence you then to 10 years in prison, suspended and probated for 10 years, $1,500 fine, probated. But if CPS, Mr. Piddle, and probation, I don't want to double anything that CPS is doing. So if CPS is providing her UAs, then that will be acceptable to the court. Are you employed?
Not currently, no.
How are you supporting yourself?
Well, my family's been helping me out.
How old are you?
I'm 28. I just lost one of my twins, so I've just been trying to do the grieving counseling and stuff.
So you're receiving counseling for that?
Mhm.
All right, I'm sorry that happened. All right,
Sorry, Judge.
no, go ahead, Mr. Piddle.
She's done a parenting class through CPS, but she'd be glad to do one again through court if you.
No, she'll just need to provide proof of that to probation. All right, this is what the court is going to do. As previously stated, sentence you to 10 years in prison, suspended and probated for 10 years, $1,500 fine, probated, CPS compliance, parenting class.
You're going to have to start making better choices in your life. Otherwise, you may find yourself in prison. This is not just a suggestion, it's a prophecy. Judge Boyd delivers this final warning with a weight that hangs in the air. Mitchell has just been given an incredible opportunity, a 10-year suspended sentence for manslaughter with her GPS monitor removed. She is walking out of the courtroom with her freedom. The judge has laid out the terms for success and the dire consequences of failure. The line has been drawn in the sand. For the viewer, this is the ultimate cliffhanger. Has she truly understood the gravity of this second chance, or are these words falling on deaf ears? The stage is now set for her return.
Classes, the UA hotline, proof of employment within 60 days. There's to be no employment as a home health care provider or minor. And if there is a counselor, Mr. Piddle, who says that at this point in time, she's not able to work because of the tragedy, they'll need to provide proof of that to probation. We're going to want field visits 2 times per month. Probation, is there anything else that Ms. Mitchell needs?
No, ma'am.
Ms. Mitchell, is there anything else that you need from the court in order to be successful?
Less than a year later, the judge's warning becomes a reality. Brianna Mitchell is back, and the tone is completely different. The previous hearing was about a potential second chance. This one is about consequences. The document she's reviewing isn't a plea bargain for probation. It's a motion to revoke community supervision. The foreshadowing has paid off, and we're about to learn exactly how she violated the trust placed in her by the court. The question is no longer if she will go to prison, but for how long. The list of violations is staggering, proving she didn't just stumble, she sprinted headfirst back into the criminal justice system.
No, ma'am.
Just one more thing. Her significant other's mother lives down.
Pleading, true. 3 times in a row, Mitchell admits to a spectacular failure to comply with her probation. Let's break down these new offenses. First, possession of a controlled substance, the very behavior her probation was designed to prevent. Second, failure to identify herself as a fugitive, which shows a clear intent to deceive law enforcement. And third, evading arrest or detention, meaning she actively ran from the police. This isn't a minor slip-up like missing a meeting with her probation officer. This is a deliberate crime spree that shows a complete disregard for the law and the lenient sentence she received. The state is no longer recommending supervision. They are asking the judge to revoke her probation and enforce the original 10-year prison sentence.
In the valley, and she's in hospice care. Would you like me to submit a motion for her to go down there for that? Or
Do you have any objections to her being allowed to visit someone in hospice care, Mr. Nisbet?
No, Kelly, refresh me. She's been on.
Now, the defense deploys a complex legal maneuver. Her attorney is arguing that she should receive credit for time she served in federal prison on a completely separate case, even for time served before the manslaughter offense even occurred. This is a strategic attempt to chip away at her impending 10-year state sentence. Essentially, they are asking the judge to count her past punishment for a federal crime towards her current punishment for a state crime. It's a long shot, but in sentencing, every single day of credit matters. The attorney is being diligent, trying to find any possible way to reduce the actual number of days his client will spend behind bars, even if the 10-year number on paper remains the same.
Tracking with the permission to go to the hospital.
Just when it seems like the sentencing is finalized, the judge spots a crucial detail that everyone else missed, an affirmative finding of a deadly weapon. This is a game changer. An affirmative finding is a formal declaration by the court that a deadly weapon was used in the commission of the crime. Legally, this has massive implications. It means the defendant will have to serve a much larger percentage of their sentence, typically at least half, before becoming eligible for parole. The defense attorney seems caught off guard, noting it wasn't part of the plea negotiations, but the judge points directly to the original indictment. It states Mitchell caused a death by discharging a deadly weapon. Whether she or her co-defendant pulled the trigger, the finding attaches to the case, and it makes her 10-year sentence significantly more severe.
Appointments and everything like that? Yeah, no objection, Judge.
All right, then there'll be no objection to that. Rebecca, she will be allowed to travel to visit the person who's in hospice care. Mr. Piddle, you'll just need to make sure that you provide proof of that to probation.
and then lastly, the court wished for me to submit a motion to remove GPS, or would the court wish for it to stay on for a little bit longer?
Mr. Nesbitt, are you okay with removal of GPS?
Yep.
Okay, then GPS will be removed. But even though you're traveling, you'll still have to let probation know where you're traveling.
I can't believe you're counting that.
And I'll order GPS removal.
Thank you, Judge.
You're welcome. All right, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Mhm.
All right, we can go off the record. Ms. Mitchell, you're going to have to start making better choices in your life. Otherwise, you may find yourself in prison. Do you understand?
Mhm.
All right. Court is going to call 2020 CR 4098A, State of Texas versus Brianna Renee Mitchell. Can I have parties announced for the record for the state?
Brittany Sparks,
Defense?
The attorney of record, Monica Guerrero. I'm covering for Ms. Guerrero. Joseph Stateson. Ms. Mitchell, would you give this judge permission for me to do the plea in case of Monica Guerrero?
That's not.
All right, I'm gonna need you to speak up, okay?
Yes.
All right, are you Brianna Mitchell?
Yes, ma'am.
All right, I'm showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Brianna Renee Mitchell who was placed on community supervision in 2020 CR 4098A for the offense of manslaughter on December 10th, 2021 for a term of 10 years? Is that you?
Yes.
All right, state.
Yes, Judge, violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of possession of controlled substance, penalty group 1, in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of fail to ID fugitive intent to give false information in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True.
We'll waive the other violations.
Any objections to the state's waivers?
None.
All right, did you understand by pleading true to violations 1, 1, and 1, the court could find it true, grant the motion, and sentence you up to 10 years?
The courtroom chapter is closed, but the full story is only now coming to light. With the legal proceedings over, we now shift to a press conference where a law enforcement official finally fills in the missing pieces. The abstract charge of manslaughter is about to get a face, a motive, and a chilling narrative. This is where we learn the why that Judge Boyd was searching for in the first hearing. All the speculation ends here. The official lays out the cold, hard facts of the original crime, revealing Mitchell's precise role and the brutal reality of what happened on January 2nd, 2016. What we are about to hear will recontextualize everything we just saw in court.
In prison and up to a $1,500 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1, 1, and 1?
Yes.
The court will find 1, 1, and 1 true. Is there an agreement?
Yes, Judge, we're asking that you grant the motion, revoke her probation, and sentence her to 10 years in TDC. In addition, Judge will be taking into consideration cause numbers 2022 CR 10345B, County Court cause number 692652, County Court cause number 692653.
Is that the agreement, defense?
It is, Your Honor, and I believe I may have made a clerical typo on the certificate of appeal. I may have put the case in TIC instead of the NPR. That's my mistake.
Yes. No, I'll correct that. Is there any objections to the court correcting that with the proper cause number?
None from the first. And if I may put something else in the record, Your Honor.
Yes.
This offense was created during a time where Ms. Mitchell was on federal release, supervised release. She has federal back time.
This press conference completely rewrites the narrative. Brianna Mitchell wasn't just scared or in the wrong place at the wrong time. She was the getaway driver in a targeted, vengeful drive-by shooting. Her co-defendant, Daniel Jimenez, was the triggerman, but she knowingly drove him to the victim's house so he could execute the plan. The victim, Daniel Sinfield, was shot and killed while working on his car in his own front yard. The motive was retaliation for an earlier dispute. The reason for the delayed justice is also revealed. Both Mitchell and Jimenez were arrested and served time in federal prison on unrelated drug charges shortly after the murder, putting the homicide investigation on hold. This wasn't a reckless accident, it was a planned killing.
And post the offense, she did time in federal prison. I have some dates if I could put those on the record.
Yes.
She was in custody in federal prison or federal custody on April 18th, 2016, where she was sentenced November 17th, 2016. And she was not released until April 3rd, 2020. When she was released April 3rd, 2020, it was supervised release. And there was a revocation hearing. And she has federal custody time from February 18th, 2022 to April 13th, 2022. And we ask that she be given credit for federal time in addition to the Bexar County time.
So you're asking for credit from April 18, 2016 to April 13, 2020?
We are, and I did explain to my client that that is prior to the offense date, but she was still in custody post that also, and that it's the court's discretion to award time.
So with regards to the dates from April 18, 2016,
Now we have the complete picture. The two investigators standing behind the speaker aren't just props. They represent years of work on a cold case that finally led to this arrest. It's a stark reminder that even when offenders are incarcerated for other crimes, justice for their most serious offenses continues to grind forward. The plea to the public for more information on this case, or the other murder case mentioned, shows that law enforcement's job is never truly done. The community's help is vital in piecing together these complex criminal puzzles. The press conference serves as a bookend, confirming the dark reality behind the sanitized courtroom proceedings and highlighting the relentless effort required to hold individuals like Brianna Mitchell accountable for their actions.
to April 13, 2020, was this case open on a motion to revoke or no?
I don't believe it was on a motion to revoke.
All right, was this case pending?
I have to,
Right.
I can
So-
check one moment, Your Honor.
Okay, so that's what I want to know about that. But with regards to the February 18th to 2020, February 18th, 2022 to April 13th, 2022, this was pending, correct?
Yes.
All right, so she will definitely receive credit for those dates. I just need to check on the April 18th date. Well, it appears, Ms. Sparks,
Yes, Judge.
on this case, I'm being informed by the clerk that this case was actually on the system January 2nd, 2016.
Yes, Judge, that's what our computer shows.
Okay, so we can go back on the record, Brenda. So are you asking the court to follow this agreement?
Yes.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court is finding 1 and 1 true. The court will follow your agreement, revoke, sentence you to 10 years in the prison, take in consideration 2022 CR 10345B, County Court Cause number 692652, 692653, give you credit for any time served, and the court will give you the credit served in federal custody from April 18, 2016 to April 3rd, 2020, and February 18th, 2022 to April 13th, 2022. Is there anything else from either side with regards to sentencing?
No, Judge.
Nothing from defense.
All right. For some reason, there's no affirmative finding on this of a
On the
deadly weapon.
original?
Yes. Let me see something, just so I know. I don't know what the underlying facts of this case were. Just give me 1 second. All right, yeah, it's involved a gun.
It appears that my client appears that it was with the co-defendant who had a gun. Her client didn't have a gun, but that was not negotiated with the district attorney's office with Marcus prior to this.
All right, because I mean, according to the, and I know this is before your time, Mr. Statesman, but according to the indictment, it says that Brianna Mitchell did recklessly cause the death of an individual, namely, the complainant, by discharging a deadly weapon. So this is pre this attorney, Ms. Mitchell, but that's what's in the paperwork. So there's going to be an affirmative finding. So there's an affirmative finding of a deadly weapon. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck. We can go off the record. I saw in this case where parenting classes were ordered for you. So here's the thing, someone else is taking care of your children or your child. When you are released from prison, and at some point you will be, Do not go up to the house acting as though, here I am, let me put my rules in place and disregard whatever rules have been set for your children. You understand? You're going to have to humble yourself. All right, good luck to you.
This is a murder arrest on a 2016 case. January 2nd of 2016, the suspect who you just saw, Brianna Mitchell, Brianna Mitchel, date of birth 9/10 of 1993. She and Daniel Jimenez had shot and killed, or let me say again, Brianna Mitchell had driven the vehicle when Daniel Jimenez shot and killed the victim in this case, Daniel Sinfield, a gentleman in his late 30s, early 40s, on January 2nd, 2016. It appears that this was stemming from an earlier disagreement between the other suspect in this case and the victim, Mr. Sinfield, where Sinfield had actually fired a weapon in the general direction of Jimenez, the suspect. A couple of days later, the suspect engaged the help of this other suspect, Mitchell, in driving him over to a residence where Daniel Sinfield was located. Sinfield was out in the front yard doing some work on his car when the vehicle driven by Ms. Mitchell drove up to the victim. The suspect in the case, and the other suspect in the case, Mr. Jimenez, actually leaned out the window and shot the victim one time, and he died there on the scene. The two suspects in this case, Jimenez and Mitchell, both actually went to federal prison for several years on an unrelated drug charge. Ms. Mitchell just got out of federal prison this past week, and she and Mr. Jimenez were both indicted for the murder case. The other suspect in this case, Mr. Jimenez, is due to get out of federal custody in 2021, and he will also face this murder charge as well once he gets out of federal custody. Esto se centra en un caso que pasó en 2016, el segundo día de enero 2016. Los dos sospechosos, Brianna Mitchell y otro sospechoso que se llama Daniel Jimenez, ellos fueron a la casa de la víctima, Daniel Sinfield, Sinfield. Ellos se enfrentaron con la víctima en la yarda de enfrente de esta casa. El sospechoso Jiménez disparó una pistola hacia a la víctima. La víctima falleció en la escena de los hechos. Los dos sospechosos huyeron de la escena. Hace un tiempo que los dos sospechosos fueron a la prisión federal por unos cargos de drogas que no son relacionados al homicidio este. Nuestros oficiales siguieron investigando el homicidio y esta semana ellos lograron aplicar por orden de arresto por los dos sospechosos. La sospechosa Mitchell, ella salió de la prisión hace unos cuantos días y la arrestamos por este homicidio. Jiménez le toca salir de la prisión federal en 2021. Él en este tiempo va a enfrentarse con este cargo de homicidio también.
This is the second murder charge BCSO has made in the same day. What can you say about the investigators working these?
Yeah, well, the investigators, albeit that the county is undergoing a new normal for the time being with regard to COVID, our investigators are continuing to work their cases just as hard as they ever did. And in fact, this is our second arrest today for a murder case. So just want everybody to know the BCSO continues to work hard to protect and serve our community. Este es el segundo arresto por homicidio este día. Nuestros oficiales, nosotros estamos trabajando bajo nuestras reglas nuevas con COVID, pero nuestros oficiales siguen trabajando en sus casos y siguen arrestando a los criminales cuando se toca. Nos da mucho orgullo poder decir que nosotros todavía seguimos protegiendo a nuestra comunidad con honor.
Anybody has any more information on these two cases?
If anybody's got any information on this case or the previous murder case, they can call 210-335-6070 or they can email.
From a suspended sentence to a 10-year prison term with a deadly weapon finding. Brianna Mitchell's journey through the justice system is a stark lesson in accountability. She was given a second chance, a path away from prison explicitly laid out by the judge. But in less than a year, she was back in cuffs, having committed a new string of crimes that made her incarceration inevitable. The judge's warning, "You're going to have to start making better choices," proved to be a prophecy she couldn't escape. In the end, the truth of her role as the driver in a fatal drive-by shooting came out, cementing a tragic legacy. What did you think of the judge's decision to grant probation in the first place? Let us know in the comments below, and don't forget to subscribe for more in-depth courtroom analysis.